All right, I think we should kick things off. So, good afternoon, everyone. Like I said, welcome to today's webinar. We're going to be discussing employment law updates in Singapore and especially focusing on navigating termination. Always a hot topic. My name is Sanam. I am the Employment Counsel here at Employment Hero, and I am joined today by the lovely Natasha from Bird & Bird. She is counsel there. Natasha, could you give us a little bit of a breakdown about your role and what you do at Bird & Bird?
Sure, Sanam. Good afternoon, everyone. Thank you so much for joining us on a rather dreary afternoon. I am Natasha. I am Employment Counsel at Bird & Bird Singapore office. So we deal with contentious and non-contentious employment law issues in Singapore and in the APAC region.
Oh, wow. That's pretty interesting. And I'm sure you must get such a mix of work with it being contentious and non-contentious as well.
Yes, we do. Termination is a hot topic.
Oh yeah, well, I mean, everyone's in for a treat today. I mean, we definitely have Natasha's expertise here. So before we get underway and before we kind of start off the webinar, I just wanted to do a little bit of housekeeping. Please, everyone know that this is a Q&A webinar, so we will have allocated time at the end of this webinar for your questions. So if you see at the bottom of your Zoom screens, there will be a little box where you can put in your questions. Absolutely use that. That is definitely what we're here for. So please feel free to ask any questions and we'll get to them at the end of the webinar. Now, this will also be recorded, so please don't worry about frantically writing everything down. Enjoy this lunch session, sit back, take the information in, and afterwards we will be sending out the slide deck with the recording and some extra materials as well. So now that we're getting stuck into it, I just wanted to give a bit of a quick disclaimer. Please know that this information is provided to you in good faith. This is only general information. We have Natasha here today, and I will leave her details on the last slide, which will give you, a good indicator to contact her if you have any specific legal issues that you're dealing with, contentious, non-contentious issues, and she will definitely be able to help with that. And so now, as we get underway, the agenda for today. Well, we will be talking about a few different things. Firstly, employment law updates, looking at that, and then we'll move on to terminations and then further down into the Q&A portion of this webinar. So to kick things off, let's have a look at employment statistics. So I know a lot of you out there, when you're considering, the likelihood of a successful claim, maybe you've received a claim or you're an employee filing a claim and you're looking at, what is the actual odds of this kind of going ahead and what's going to happen. The best way to look at it, I would say, is to look at the statistics of what happens. And Natasha has kindly done some research here into, employment standards reports. And it would be great, Natasha, if you could give us your observations on what you've seen.
Yes, thanks for that, Sanam. So as you can see on the slide, we've pulled across some statistics that's been published by the Ministry of Manpower back in 2021. So key facts are listed on this slide. And I thought what was quite interesting is that, actually out of 1 in 4 claims, dismissal claims that are lodged at the TADM, were assessed to be substantiated from an employee's perspective. And I think that's quite interesting because it actually shows that less than 50% of cases are properly substantiated. It could be that, from an employee's perspective, certain documentation isn't done properly before they are filing a claim. But it could also mean that, maybe settlement is being met out by employers before a claim is even brought. So I thought that statistic is quite interesting. Another interesting statistic I thought to share is that more than half of these claims that are brought are actually resolved at the TADM stage. For those of you in the audience who do not know what the TADM process is, it's actually a mediation stage. So before an employee can bring a wrongful dismissal claim to the Employment Claims Tribunal in Singapore, it is a requirement for a claim to be transferred and be heard by way of mediation at the TADM first. And I think that's quite useful because, you know, the statistics don't lie. More than half of these cases are resolved at the TADM. And we see that, you know, less than half is eventually referred to the Employment Claims Tribunal for an adjudication.
Okay. And at the TADM level, is it normally kind of like a confidential discussion? Is there like a mediating or a mediator that sits there?
Yeah. So at the TADM stage, it is confidential, and it's a rather informal process held by the TADM. The TADM will appoint a mediator, and the representative from a company will attend this mediation session, and the employee will also attend. And it's, you know, to really facilitate informal sort of negotiations and conversations to try to breach the gap between both parties. You know, this may result in some form of settlement that can be recorded at a TADM stage, or, you know, perhaps the employee then decides to withdraw his or her claim at that point in time.
Okay, all right. So there are a lot of avenues that are created from just that one step in the process. So that explains potentially the 1 in 4 statistic in terms of, you know, things settling there, or maybe not having enough documentation, or maybe withdrawal of a claim as well.
Yeah, definitely.
All right, this is quite interesting. And I think now we'll transition a bit into the employment law updates that have come up. So obviously we've seen, you know, updates coming up, but now we're going to look at maybe the next 6 months to see what's going to be arising. And I'm sure we're going to kick things off by discussing employment passes. So Natasha, there's been, you know, conversation, and it's been said that changes to the employment passes are to complement the resident workforce. So what are these changes actually going to be, and what do they mean for employers?
Yeah, sure. So you've touched on a really great point. There are quite a lot of changes in the employment passes sphere. Beyond that, just particularly in immigration for Singapore, we've seen you know, the tightening of immigration laws in Singapore, especially with the introduction of what we call the Compass framework. And essentially, this framework is coming in 1st of September of this year. And it would impact most employers in Singapore because we think that hiring foreign professionals is going to be more costly, more expensive than ever. The spotlight is also going to be on the educational and professional pedigree of these candidates and the overall workforce diversity. And what this actually means for employers is that, you know, we need to think ahead, we need to plan ahead, way more in advance for business immigration, because with the Compass framework, it's no longer, you know, ticking the box on meeting the minimum qualifying salary. There are quite a bit of criteria that's going to be put in place when assessing if a person is going to be eligible for an employment pass application or not.
Okay. Before we touch on the eligibility criteria with Compass, how long do you think it would normally take for somebody that was recruiting to maybe have a look at, you know, meeting all of the requirements and the standards?
Yeah. So typically, an employment pass application would, in my experience, take about anywhere from 3 weeks all the way up to 8 weeks if there is some form of appeals that's required, or if the Ministry of Manpower comes back with, you know, any sort of follow-up for documentation. So it's quite a lengthy process. I highly encourage HR to, you know, take a step back, plan your timelines properly when you're looking at employment pass applications.
I can definitely see in practice how, you know, it can be difficult, because a lot of people are like, let's start next week or next month. But obviously there's so many processes that need to be, you know, and boxes that need to be ticked. So what might we commonly see as the eligibility criteria in this case?
Yeah. So with the new Compass framework, Compass is actually a point-based system to assess whether or not a candidate is eligible to apply for an EP. There are 4 foundational criteria, the first being salary, the second being the qualifications of a candidate, third being diversity of an employer, and the fourth being an employer support for local employment. Now, under each criteria, a maximum of 20 points can be scored. And an applicant requires a minimum of 40 points in order to pass this Compass framework and in order for a candidate to be considered eligible for an employment pass application. So that's the foundational criteria. If you do not meet this foundational criteria, there's also what we call bonus criteria in a form of skills bonus. And when we talk about skills bonus, we refer to candidates that are applying for jobs in industries that are listed under the shortage occupational list. And what this list essentially is a list of key industries that the Ministry of Manpower, is looking at, is focused on. And currently, the list includes industries under agri-tech, fintech, green economy, so people that are involved in carbon trading, healthcare, infocom technology, and maritime. So this list was recently published, I think, in March of this year, and it will apply for 3 years before it's refreshed again. So that's one bonus criteria. There's also a second bonus criteria known as the Strategic Economic Priorities bonus, which is quite a lengthy title, but basically the government has introduced some training programs, some partnerships with different tie-ups with different ministries. And, if the organization participates in these industries, then it is possible for an organization to gain bonus points from this criteria. So as you can see, it's quite it's a qualitative exercise, I would say, as well as a quantitative exercise in determining how many points you want to get for Compass. And I think HR can sort of start looking at this because it's coming into effect very soon, 1st of September this year.
Yeah, there's not much time left. If it does take quite a bit of time. So yeah, no, absolutely, I would say start having a look at it as well, and making sure, like you said, being a qualitative exercise that can take quite a long time to gather the information to make sure you've got the right and you've done the right kind of test and made sure with the employee. So I think we'll move on to some more updates. Aside from Compass, there was something else other than the employment passes that have also come up as well.
Yes. So in addition to Compass, and sorry guys, it's not on the slide, but there is also the new One Pass, or the Overseas Networks and Expertise Pass that's been introduced this year. It's been sort of a hot topic, particularly with employers who employ very high-level C-suite executives that are based in Singapore. This is a very, very good option if you require a bit more flexibility and a little bit more longevity for retaining foreign talent in Singapore. Just high-level comparison between the One Pass and the employment pass. Typically for an employment pass, the validity period is somewhere between, I would say, 2 to 3 years per grant. In contrast, for the One Pass, you get about 5 years of validity upon application. But of course, the thresholds in applying a One Pass are a lot higher. You do require a minimum qualifying salary of $30,000 a month. There are also additional criteria on the type of employer that you're working for. But again, the One Pass is quite an attractive option, especially if you're looking at moving key C-suite level executives into Singapore, because it provides that longevity for HR. And also, if they have trailing spouses who are intending to work in Singapore, trailing spouses of One Pass holders can work in Singapore on a letter of consent. By contrast, an employment pass holder's spouse will actually need a fresh employment pass to work in Singapore. They will not be able to work in Singapore with a letter of consent. So that's at a very high level comparison. What's happening in the immigration space? I think I'll quickly move on to touch on the last two updates on the increase of paternity leave from fathers, and that's going to be from 2 weeks to 4 weeks. And it's coming into effect 1st of Jan. And finally, last change is the increase of unpaid infant care leave, and that is from 6 days to 12 days. So it's quite a big increase.
And with these changes to these types of leave, does an employer have to do anything to prepare or to make any changes in the workplace?
Yeah. So I think it's a good time to maybe look at maybe refreshing your employment handbooks. As everyone should know, leave entitlements are a key employment term, and this needs to be communicated to your employee ASAP. So it will be good to do a refresher to update these clauses in your employment handbook. And last change I'm going to talk about very, very quickly is the upcoming workplace fairness legislation. It's a very, very hot topic. It is supposed to come out next year, 2024. This legislation will be modeled after the tripartite guidelines on fair employment practices. There are over 20 recommendations in the report that's been issued this February. So I won't bore you with the details. I'll just share about one recommendation, which I think really stood out to me, is the fact that, they say now that employers will need to put in place grievance handling processes to resolve grievances and disputes at the workplace. And I think that's a very useful recommendation. And I think that ties in with also, reducing the level of conflict, reducing the number of claims that will eventually go to the TADM or ACT.
I definitely have seen from practice myself that a lot of it is a communication issue, or the employee doesn't know who to raise the issue with and it gets lost in the mix. So it'll make a huge difference to actually have a process on who it needs to go to.
Yeah, absolutely.
All right, so we'll move on to the next part of the webinar, which is around grounds for termination of employment. Now, Natasha, let's say I'm an employer. How can I reasonably terminate an employee? What would be the grounds for termination in Singapore?
Yeah, this is a hot topic, very, very big. Everybody wants to know, how do I let my employees go in Singapore? Okay, so at a very, very high level, employment in Singapore can be terminated by providing notice or salary in lieu of notice, and that's covered under our Employment Act. That said, you do need to have a reason for termination, and that reason can't be discriminatory. So if you were to terminate employment because you don't like an employee's race or an employee's age, that's going to be considered wrongful dismissal in Singapore. So we've set out a few grounds of termination in Singapore which are acceptable grounds of termination. These are non-controversial, and I'll take you through each ground very, very quickly. So the first ground is poor performance, right? In the case of poor performance in Singapore, it is clear you cannot terminate employment for poor performance without providing notice. You must provide notice. And if you are citing poor performance as a reason for termination, you will need to show proof that there has actually been poor performance of your employee. And we often get, asked what constitutes poor performance, right? How do I know if an employee has, poorly performed? Can I terminate an employee because, it's very poor attitude, right? So it's more of a qualitative sort of analysis of an employee's performance rather than a quantitative, so based on sales targets and all of that. My answer to clients are always this: you should have some kind of document trail on this person's poor performance. Have a criteria in which you are marking this person's poor performance against. Any sort of poor performance needs to be communicated to the employee, right? So he or she's aware of the poor performance. And very good HR practice will be to provide a runway for this person to improve on his or her performance. And if this person fails to improve, you then terminate employment as a result of that. So that's poor performance. And then I'll move on to absenteeism. I think that's quite a non-controversial ground of termination. And as you know, under the Employment Act, if a person is absent for more than 2 consecutive days, and with no reason to an employer and no attempt to explain why this person is absent, it's considered a breach of contract. And we think that you can actually terminate employment. That's non-controversial. So I'll move on to the next ground of termination, which is misconduct. Misconduct is a unique ground of termination. It's the only ground where you can terminate employment without notice, provided that you carry out due inquiry. I will stop right there because I will talk about due inquiry in the next slide. But just know that there is that requirement of due inquiry. I'll then very quickly move on now to termination based on redundancy. So redundancy is an interesting bit in Singapore because we actually don't have redundancy laws in Singapore. We have a lot of guidelines, right, of what constitutes redundancy, what the Ministry of Manpower perceives redundancy to be, when a presumption of redundancy would arise. And that would arise where, there is no plan for an employer to replace a role. And that's where, a presumption of redundancy arises. If you're making an employee redundant, this really should be based on objective grounds. So not based on age, religion, familial responsibilities. It should be focused very much on the organization's needs. It should also be focused, perhaps on something that is quantitative, so on a person's maybe contributions to the company. So that's where the focus should be on. For employers who have engaged at least 10 employees in Singapore, as I would expect most of HR here to have to meet this criteria, you will also need to file something called a mandatory retrenchment notification to the Ministry of Manpower within 5 working days after you inform an employee that, they will be made redundant. So that's on redundancy. Now I'll come to the last ground of termination, which is an interesting ground because I think a lot of, scenarios could potentially fall under this loss of mutual trust and confidence in employees' abilities to perform a role. This is a ground of termination that stems from common law, and it's applicable in Singapore where, there may be certain instances where that's caused you to essentially lose confidence in your employees' abilities to perform a role. And it may not amount to poor performance, but, for instance, there's an employee who is, employed in a particular position. He or she is required to maintain, a level of confidentiality because of the role that he or she is being employed under. But this person, goes around to share information with, his or her colleagues during lunchtime, okay, not too careful about the sort of information that he is disclosing. Now, does that really amount to poor performance? Can't really say that, right? Because maybe he's a stellar performer on his day-to-day role. He's meeting all of his targets. So then you need to look at the nature of his role, what he's required to do, and then, perhaps for this particular scenario that I've described, you would terminate employment with notice on the grounds that, you've lost mutual trust and confidence in his ability to do his role. So that's, in a nutshell, acceptable grounds for termination of employment in Singapore.
Yeah. Well, that's really interesting, Natasha. Even with this mutual trust and confidence, I also have obviously dealt with it, in practice, and it's quite interesting because it's things like bringing the company into disrepute or things that are not necessarily misconduct per se, but they could fall under that, but it's a bit different. So it's interesting that also comes out of the bracket. And do you ever see it overlapping with other areas where trust and confidence can also come into misconduct issues as well, and there could be an overlap between the two?
Yeah, definitely. More often than not, sometimes there will be more than one reason for termination. So like the overlap you've mentioned, the loss of mutual trust and confidence, it ties in sometimes hand in hand with misconduct. But maybe for HR reasons or maybe from a management perspective, you may not want to exit someone on the grounds of misconduct. A gentler way to let somebody go would be to go via, the loss of mutual trust and confidence and terminate employment with notice.
Okay, well, no, that's good to know. I hope everyone's taken note of that too. All right, so we'll open up the floor. Actually, we've got a couple of questions here that we're going to send out and poll. So please feel free to participate. Pop in your answers as they pop up on 2 screens, and then once we go through the process, we will look at the results. So they should be due to pop up shortly on your screen. And perfect. So yeah, feel free, yes or no for either one of them around, notice and then looking at, performance improvement plans. Feel free to pop in your answer and then we'll get Natasha to give her expertise in this area.
Yeah. Yeah, I always like to ask these two questions because I find that, sometimes you get very divided answers on this. So it's always a good question to pull. I'm very curious to see what the audience has to say.
I am too, to be honest. I mean, we've done webinars in the past
Yeah.
and then interesting results. So it'll be interesting to see what people come back with now. So we'll pop up the results soon. And then they should come up on our screens shortly. All right. Wow, this is interesting.
Very, very interesting. Okay, so a whopping 67% of you say yes, you must give a reason for termination with notice. And 33% said no, you do not need to give a reason for termination of employment with notice. Very, very interesting because it's quite close. Well, it's not 50-50, but I will say that the results are fairly close. The legal position is no, you are not required to actually communicate the reason for termination of employment with notice. Now, however, and I stress the however because there has been a change to the Employment Act in Singapore back in 2019, and it's introduced a claims process under Section 14. And if employees are aggrieved for the reasons of termination, they can actually file a claim, and that's the TADM and ECT process that we've touched on earlier. So no, you don't need to give a reason for termination with notice. However, good HR practice would encourage you to, give a reason for termination if it warrants, where the situation warrants for it, because ultimately employees sometimes they would want some form of closure, and I think that helps also from a risk mitigation perspective. And we are also assuming that you do have your reasons for termination are properly documented. So a bit of perspective where the HR and the legal practice sometimes may differ. And the second question, is a PIP, a performance improvement plan necessary for termination due to poor performance? Again, the answer is no, it's not legally necessary. So 18% of you got that right. And wow, a whopping 82% actually said yes, you need it. It's necessary. Very, very compliant bunch of people we have here today. Fantastic. And I'll tell you why I tend to agree with the yes. Even though it's not legally necessary, a PIP is perfect, very, very good risk mitigation measure when you are called upon to defend your decision for making a termination decision due to poor performance. Because typically in a PIP plan, you would have, the areas of poor performance being documented out, goals which you want the employee to achieve and where the employee has fallen short. So everything would have already been documented out. You don't need to be pulling WhatsApps and Slack chats from, months and months ago to, justify or support your decision. So, I think it is actually good practice to have a PIP in place.
That's so interesting. So I think the key takeaway here is document, have as much evidence as you can when you're looking at doing something like a termination. But I'm not going to let you off that easy, Natasha, because you did mention due inquiry. And, I've heard that, it's important when you're dealing with misconduct, like you said, but what does it actually mean? Do I have to investigate things or what does this all mean?
Yeah. We get this a lot. And it's because rather unhelpfully, the Employment Act doesn't define or provide you any sort of specific timelines or requirements of what due inquiry is. But ultimately, what HR needs to know is that when you carry out due inquiry, there really are a few key elements you need to have in place. So number one, and it's stated on the slide, your employee needs to be told of what their alleged misconduct is. This needs to be communicated very, very clearly. I always encourage HR to communicate this written in a written form because you have everything again documented. And also the employee needs to be provided an opportunity to respond to these allegations. And when the employee's alleged misconduct is being heard at a, maybe it's a due inquiry panel, the people that are appointed onto the panel shouldn't be in a position of conflict or maybe an interested party to this inquiry, because that could potentially suggest some sort of biasness against your process, and that's not something that you would want to deal with. What's another common question that we get from HR is, what happens if the matter goes to the Employment Claims Tribunal and the judge disagrees with my findings? And to me, that's always a really, really interesting question and a hot topic, because, as HR practitioners, you are not there to investigate, this matter like an investigator. You're not being held at that threshold, right? At a criminal court threshold for that matter. Your job really is to, carry out the investigation the best you can, ensure that you are following due process, and have a logical flow as to how you reach your findings. And, don't be afraid to say that, based on the facts that I've received, actually, it's inconclusive. Like, I can't come to a conclusion objectively. So don't be pressured to land into a finding if the facts simply aren't there. Or, if you need more time for the investigation, you need to interview more people, then, all of that are options that HR can take.
Right. And yeah, I think it's definitely true that a lot of people think it should be substantiated or not, when a lot of the times the process actually leads you further in, and then you actually end up interviewing more people, finding out what's happened, and then sometimes it's not substantiated what ends up happening in the end, or sometimes it is. So I think it's just a matter of going through the process, like you said. So the question that I'm sure everybody has is, now we know how to do everything right. So what happens if an employer actually finds out that there is misconduct?
Yeah. So the answer is on the slide. Three options. Well, three common options. I'd say that there could potentially be more, but the first would be, to downgrade an employee. Say you found misconduct, and as a result of misconduct, you think that this person is no longer able to cover the role that he or she is currently covering. You need time to rebuild that trust. So you downgrade an employee, maybe from a band 5 to band 4, for instance. So that's one option. And the second option is suspension of employment. That's quite a serious option, I would think. And it could typically be used in a situation where, there may be some sensitivities between this employee and maybe a victim, for instance, if this is a sexual harassment matter, or any other sort of maybe bullying, power, harassment sort of issue, where you need to keep employees apart. You may wish to put this person on a suspension, paid suspension or unpaid suspension. For unpaid suspensions, it cannot exceed a period of 1 week. And usually you would put an employee on unpaid suspension if you are still undergoing an investigation and you need that time. And the last option is termination of employment without notice. So the notice period does not need to be observed.
Oh, okay. So there are options that are available, but I'm wondering now, okay, let's say that I've been terminated. What actually constitutes wrongful dismissal? We've spent time looking at, grounds for termination, but what happens if an employer just gets it all wrong?
Yeah. So I think this is a phrase that HR probably won't want to see: wrongful dismissal, right? Yeah.
Close eyes.
Close eyes. Yeah, that's right. So what is wrongful dismissal in Singapore? It can be it's quite a wide ambit, I think. So you can see from the slide that wrongful dismissal could potentially be a situation where employment is being terminated due to discriminatory reasons. So, for instance, you've discriminated against somebody's age, race, gender, religion, marital status, and family responsibilities, deprivation of benefit, or to punish an employee for exercising his employment right. Now, I'm just reading off these slides and talking about these factors just like that. But I think it's maybe a bit more useful if I gave you a real life example of what could potentially, result in wrongful dismissal. Say you have an employee that's, taking sick leave, and it's statutory sick leave. This person's on hospitalization leave and still within his 60 days of hospitalization leave. Now, he's within the 60 days of hospitalization leave. But your company just can't go on anymore with this person that's on sick leave, and you terminate this person while he's on his statutory sick leave. Now, in that scenario, an employee could potentially bring forward a wrongful dismissal claim and say, look, you are actually punishing me for exercising my statutory right to take hospitalization leave. Like, why am I being, dismissed at this point in time? So that is, I guess, a very real life example that I'm sure HR may encounter in practice where wrongful dismissal can occur. Of course, there are ways, right, to exit a person that is maybe on prolonged illness leave, but it's again risk management, and please consult your lawyers if you want to do something risky like that. So I'll move on to the next point. On the burden of proof element. So earlier, we've discussed, should an employer give reason for termination or not? What's very interesting is in Singapore, if an employer terminates employment with notice and you give reason for termination, the burden of proof is actually on the employer to prove, right, that the reason that you've terminated employment is what you say it is. So for example, if the termination is actually based on it's really poor performance. Okay, this person's just not performing well, but you don't want to use poor performance. So on the document you say, I'm making this person redundant. Okay, but actually this person's not redundant. You're replacing this person's role next month. But in the notice of termination, you say, I'm making you redundant. Your role is being made redundant. Now that scenario, right, could potentially be a wrongful dismissal, because the employee could say, look, I know my position's not being made redundant. You've just replaced this role with someone actually, and an employee could potentially contest that. So the reverse is, if you are silent on the reason for termination, then the employee and you have provided notice for termination, the burden of proof is actually on the employee to say that the termination is wrongful. So the employee would then have to say, point towards reasons to support his or her claim that you have terminated employment wrongfully. Wow. And I think I've touched on the last point already. For poor performance, you cannot terminate employment without providing notice. You must provide notice. Misconduct is the only ground after, assuming you've done you agree, where you can terminate employment without providing notice. So I'm going to pause here to let you digest all the different grounds that could potentially constitute wrongful dismissal. And I think I'll touch on the claims regime a little bit because I think HR might want to know. In Singapore, where a wrongful dismissal claim is filed, it, like I've mentioned earlier, must be first filed with the TADM for mediation. If a settlement or withdrawal is not filed, then the matter will then move on to the ECT tribunal. And at the ECT, an employee can claim one of two things, right? The employee can claim a reinstatement of employment or compensation. And compensation is typically computed in two categories: compensation for loss of income and compensation for any sort of harm or damage that has arisen from wrongful dismissal. And the cap of claims, or how much you can claim at the Employment Claims Tribunal, is $20,000 for non-unionized companies in Singapore.
I think it's really worthwhile kind of absorbing that and taking that in, because this is, I believe that these are very common questions that come up. A lot of people will say, okay, what do I have to pay? How much will I get? And how long will this take? Or, what's the situation? So I think that's really critical and it's really important. And I know it's not necessarily on the slides in detail, but I will pop them in the notes so that you guys can have them to hand as well. So we'll kind of move towards the end a little bit and have a look at at now a case that's quite prevalent, and we'll have a look at it. It's in relation to signing and accepting terms in the employment contract. So Natasha, can you give us a breakdown of this quite recent case, 2023? So
Yeah. It is a very interesting. It's a very recent case, and that's why I thought to share about it today. And I'm pretty sure some of us in the audience will probably have heard about this very interesting case. Well, in summary, what happened was there is a company that declared a bonus on the 23rd of March. And then the employee gave his notice of resignation 2 days later on the 25th of March. And the bonus was actually paid to the employee on the 26th of March. And what happened was the company then sued for the return of the bonus. Following a trial, it was actually found that, the employee needs to return the bonus and CPF to the company. And the reason for this is because the employment handbook the clause in the employment handbook was deemed to have been incorporated into the employment contract. And the fact that this employee claimed that he was not aware of this clause and that his employer should have brought his attention to this clause was not accepted, actually. The judge actually thought that, it's pretty clear that the clause in the employment handbook had been incorporated in the employment contract. Now, it is, again, I think, a battle between what's the legal requirement and what's good HR practice, because, I can potentially see a lot of HR thinking, oh, then that's great, right? I'm just going to slip in everything into the employment handbook when I'm changing it and, quietly do it and not tell any HR people, not tell all my employees on what I'm changing. But I think the learning point here really is this. If you're making changes into your employment benefits, or if you're making alterations, or where there are things which impacts an employee's salary or bonuses and commission, it's actually good practice, in fact, to bring this to their attention. I dare say that, if HR actually had brought this clause to this employee's attention, he could very well be not caught off guard, and the claim wouldn't even have begun, because we've done all the necessary clarifications or negotiations upfront, and then we might not have this 2023 case. So that's just my personal views on the matter. I just thought it would be interesting to share this case with the audience today.
I think it's definitely a very relevant case and a very interesting one, because I have seen many employers trying to sneak things into handbooks to get by, because a lot of employees won't sign them or they won't read them again, especially when you send it out as an update. So no, I think this is really relevant, and it really shows that certain key terms and key components of employment really need to be communicated with the employee. So we'll move on to our final bit of the webinar component and the presentation component, which is around what would be the key takeaways today, Natasha. If people were walking away from this feeling very full from their lunch and thinking that this was a lot of information, what would you say would be the best practices they need to follow?
Yeah. So the 3 points, and I think it's a common theme that's flowed through the entire webinar today. Have open communication with your employees. Even though from a legal perspective, sometimes, like in the previous case, you don't actually need to alert your employee to these clauses. We recommend early negotiations, early communication with employees, so they are aware of what your company's practices are. That's the best risk mitigation strategy out there. And the second point would be, to make sure that there are policies in place to document and to remedy poor performance. So the 82+% of you that said yes to PIP, I'm sure that that's no issue for you. Just business as usual. And then the final point would be consider a mutual separation agreement, and that deals with termination matters, because sometimes when you're terminating an employee, it's a sensitive termination matter, where a unilateral termination, so just issuing a notice of termination like that, might not sit very well with an employee, or where you are in a situation where you want to handle or manage certain exit of an employee a bit better, because there are maybe post-termination obligations you want to impose on an employee that can all be covered under a mutual separation agreement. That's also a very effective way to mitigate your risk.
All right. So we are at our last bit. I will speed us along a little bit because I know we are pressed for time. The questions are pouring in, so we definitely should get to them. There's two questions there, Natasha. So one is obviously around exchange for release or waiver in non-retrenchment, and then the other one has to do with filing a claim. So if you could address both of them just to give us a bit of information, that would be good.
Yeah, so for the audience here, release and waiver typically refers to a clause in an agreement which says, that an employee can't file any employment claims against a company for, any sort of matter that's arisen throughout the employment of an employee. In Singapore, there really isn't a specific range that you must offer to an employee in exchange of a release and waiver. But I would say that common practice that we've seen is benchmarking that to retrenchment benefits, that 2 week of salary to 1 month per year of service. But that's not a hard and fast rule. It really depends on that specific termination scenario. Then on the last question, whether or not an employer can prevent an employee from filing a claim with the TAD and ECT, the answer is no, actually. Even if you have a release and waiver. And the reason for this is because under Singapore law, the Employment Claims Act, we have something called a no contracting out provision. And what that means essentially is that if you have an agreement which tries to prevent an employee from filing a claim, that agreement is actually void. So then HR will follow up and say, then what's the point of having an agreement, right? You can't prevent someone from filing a claim. Then, we always say that, number one, having that agreement there is usually a pretty good deterrent effect. And there are also other mechanisms that we can put in place in the agreement that would maybe mitigate that risk of filing claims. So things like a clawback or maybe your staggering payments. But, these are just two out of the many different kinds of mechanisms you can put into place.
Okay, so a lot of interesting things to absorb, everyone. And I think definitely that ties in with best practices or things that employers can do to make life a little bit easier or to give them more protections. So for the much anticipated part, we will have a look at your questions. Like I said, they're flooding in, and I'll go through them sporadically and have a look at them. The first one, and it's something that Natasha and I were just discussing literally probably the second before we came onto the webinar, was around how many absences can we consider before dismissal under for absenteeism? So is 5 minutes lateness, or is it consistent absenteeism? What does it look like?
Yeah. So if we're going by, termination without notice, you're looking at 2 consecutive days, right? But I think maybe HR is more interested in the general position with notice. So I was just discussing with Sanam earlier that actually, if the role requires you to be on time, and maybe, the nature of the role requires, it's maybe it's an appointment-based sort of role where, the company is really counting on you to be on time. And this repeated absenteeism, results in this employee not being able to carry out his or her role effectively. I actually think you could potentially go under the grounds of loss of mutual trust and confidence, terminate with notice. I do not think that there is a specific number of times, like 5 times, 10 times, that an employee needs to meet in order before you can go under that ground. I actually think that you can terminate under such a ground even after, say, 2 or 3 instances if this really impacts the way you think this employee can conduct his or her role. But terminate with notice.
Okay, and with Compass, as you can imagine, we did get a few questions. One of them is around, basically if you need to do job postings on My Career Future, or what's the situation with September just around the corner?
We have a lot of those questions. Yes, you do need to put in that job advertisement for 14 days for employment passes, unless the role falls under one of the exemptions. So, if you're coming in via the ICT-EP role, or if the role is for $20,000 and above, then you continue to be exempted.
Perfect. Okay. And is there any updates that have happened on the Depends Pass, which is to work in Singapore?
No changes at the moment. So you still need the minimum qualifying salary of 6,000 in order to sponsor a DP, dependence pass, but no changes yet. Yeah.
And I'll just have a quick look. So this is a question that has we kind of touched on, but can you dismiss under moral misconduct? So, they've morally and ethically done something wrong in the workplace.
Yeah. So, well, I don't know the full facts of this person's question, but thank you for asking. Technically, you could. Depends on what sort of morals we're talking about, but I think potentially you could with notice under the grounds of mutual trust and loss of mutual trust and confidence. Yes.
And do the grounds for termination rules apply for expats as well as for Singaporean nationals as well?
Yes. So it's universal. We don't make a distinction between foreign employees and Singapore employees.
And so I think we've covered this off, and I think the answer is yes. But does an employer have to document proof if the termination is with notice or with pay? Do they still need some sort of evidence?
Yeah. My answer will always be yes, because you never know when you need that, especially if an employee were to file a claim against you. So I always recommend, yes, have your documents or have your reasons in place.
Okay. And we touched on performance improvement plans, and one of the questions that came up was whether performance appraisals would be sufficient enough for senior management instead of doing a performance improvement plan.
Yeah. That's a really interesting and a really good question, because sometimes at a really high level, like C-suite level, putting someone on a PIP is just not an option, because how are you even going to gauge this person's performance, right? At such a senior level. So I will say that yes, performance appraisals are a really useful tool. But perhaps exiting someone at a really senior level, because it will have potential ramifications for the company, you may be looking actually at a mutual separation.
Okay. And on the point of redundancy that we discussed before, I think I know the answer to this one, but I'll leave it up to you, Natasha. If we have an internal role that's separate from the candidate's role that they were doing that we need to fill, or the employee's role, sorry, can the employer still terminate based on redundancy, even though there's another role that they can do in the company?
Yes. I do think that it is possible to still make this person redundant just because this person has another role internally. But ultimately, it's the employee's choice whether or not he or she wants to be redeployed. So you can still make this employee redundant.
And on that point of kind of voluntary redundancy, is there any framework or guidance around that?
Yeah. So there is a very, very useful advisory called the Tripartite Advisory Guidelines for Managing Excess Manpower. That's available on the Ministry of Manpower's website, and that provides, at a very high level, what are some of the key considerations you need to take into account of when carrying out a redundancy exercise. Of course, this is just high-level guidance. I do encourage that, you reach out for legal representation to walk you through the entire termination process.
Absolutely. There is no difference, there's nothing better than actually coming and reaching out to a legal representative that can actually give you specific advice. It's much harder in the broader sense. And one of the things that I've seen come up in my like when I've been practicing is what happens when you have a panel and you're looking at a due inquiry and you are considering if the person is unbiased or if they are being biased that's sitting on the panel. What happens in that situation?
Yeah. So I can't speak for all organizations, but I think quite a fair number of organizations would typically have HR on the panel. And then the other members are either members of the department that have no direct link, or reporting link to the accused, or another member of management that's been appointed to sit on the panel. If the panel comprises of someone with a direct link or direct report, be it reporting to or reporting under, we generally try not to have such members sit on the panel because there could potentially be bias.
Okay. And with redundancy, again, seems to still be a hot topic. I think that the answer would be that yes, people can be distributed and the role can kind of be distributed out. But someone has asked, what if the particular tasks and duties that are part of that role could be distributed and other people could do them? Can that role still be made redundant?
Yeah. Yes, I think so, because the nature of that role would have changed already. And I do think that you could still make that role redundant, because I suspect what this person is probably saying is that, this is a role that's originally held by like one person. And then due to some sort of reorganization, maybe that role is being spin off such that certain functions are going to, different people. Even in that scenario, I will say that because the original role is no longer available, that would be a redundancy.
Okay. And in terms of termination, what's the minimum notice that employers need to provide their employees?
Yeah, so we'll have to look at the notice of termination. I mean, the notice period that's stated in your employment contract. If not, there are minimum periods that's provided under the Employment Act. It goes anywhere from 1 day up to 2 weeks, depending on the length of service.
All right. So we will go through a few more questions before we wrap up. But it seems like, I'll see what else we've got here.
So many questions.
So many. So do we need to provide salary in lieu of notice for dismissals under misconduct?
Yeah, so for salary, for termination without notice for misconduct, you do not need to provide salary in lieu of notice. It would just be an immediate dismissal.
And so I'm guessing if an employee is, it says pleads guilty, but I'm guessing if it's that they're found to have, engaged in misconduct, can the employee be suspended with no pay? Is that an option instead of dismissing the employee and then bringing them back into employment?
Yeah, you can suspend an employee on no pay, but that period cannot exceed 1 week. If you wish to exceed a week, you do actually need to make an application to the Ministry of Manpower and request for approval for a longer period of time. But that's, again, assessed on a case-by-case basis. The Ministry of Manpower can always come back to say, no, we disagree. We do not want to give you a longer period of suspension. Yeah.
I'm finding this one very interesting, Natasha. So let's say that you have a show cause letter or a letter that's presented to the employee and you've done your due inquiry. Can that be WhatsApp communications as a method of doing the investigating, or does it need to be well documented past WhatsApp or Slack messages?
Yeah. That's always but it's actually a really great question, a very practical question. The short answer is yes. It is possible, although not the best practice, to have everything on Slack and WhatsApp. But it is possible because the law doesn't prescribe the medium in which you want to carry out the inquiry. But I suspect that you may have internal HR policies on the use of personal devices when dealing with work. So you might want to make sure that you're not infringing on any of those policies.
Okay. So I'll just do one more, and that's just around redundancy notice. How much time do you need to give an employee, and is there any compensation that needs to be paid?
Yeah. So there again, like I said, there are no redundancy laws in Singapore, but you are encouraged to engage in consultations with employees in advance prior to the actual redundancy exercise. So anywhere from 6 months prior. And that's always encouraged, but not legally mandatory. And in terms of payments, while there aren't any statutory payments which are required, the guidelines I mentioned earlier recommend 2 weeks of salary to 1 month of salary per year of service for employees with at least 2 years of service. The guidelines also mention that an ex gratia amount can be paid to employees with less than 2 years of service.
All right. Well, Natasha, thank you so much. You have flown through so many of them. We still have questions pouring in. So what we will do is we will try our best to answer them after this webinar and send through the answers. Obviously, with parameters around certain questions and things like that. But we will make our best efforts to get through, as much as we can. So I just wanted to say thank you to everyone. Thank you so much for joining us today. What a lovely lunchtime session. You guys definitely weren't busy eating your lunches, that's for sure, with all the questions that have come in. And please keep in mind that a survey is going to pop up after this webinar. And if you could fill it out, it'll be great because it gives us an understanding of what we can improve on and what you liked or disliked. So thank you so much. Natasha, thank you so much for being here. Amazing experience, wealth of knowledge. I really, really appreciate it.
Thank you so much for moderating this, Sanam. It was really, really great.
Oh, no problem at all. Well, I'm sure we'll have Natasha back later on as well for future webinars. But thank you, everyone. We will be sending out additional resources as well as the recording. So stay tuned for that and have a lovely rest of your day.